Thank you again for our first session on AI. Now we are going to talk about environmental marketing. There's been obviously enormous attention about global warming, and not surprisingly, advertisers have taken notice, and it's pretty easy to find advertisers promoting the environmental benefits of their products. And once advertisers start to talk about the environmental benefits of their products, regulators and self-regulation takes notice as well. So we're seeing a lot of activity around the world on the regulatory front, on the self-regulatory front, on the private litigation front. Far too much for us to report on to today. So what we're going to do is give you some flavor of the ways in which people are thinking about environmental marketing around the world. Here's our group of speakers. You got Brinsley from the UK, you got me, you got Johan from Denmark, you got Damaso from Argentina, and Aakriti from India. So we've got a nice flavor of things happening. First thing we want to do before we dive into some examples is to just give you a brief sense of what the regulatory framework is around the world. In the US, of course, we've got federal and state general consumer protection laws, which you enforce environmental laws, environmental claims just based on general unfair, deceptive acts or practices statutes. We've also got the FTC's Guide for the Use of Environmental Marketing Claims, which provides general green guidance, as well as guidance about the use of specific environmental marketing claims. We're in this weird kind of holding pattern in the US right now, since the green guides are currently being reviewed. They've been under review for quite some time, and we're all kind of waiting with bated breath to see what the revisions are that the FTC is going to propose. The interesting thing about the green guides is they're not law, they're not regulations, they're not independently enforceable. They're simply just the FTC's view about the kinds of things that would be unfair or deceptive under the FTC Act. But what we're really also keeping our eye on is state law. Even though the FTC is not expected to probably go in drastically different directions, we're starting to see various state laws being enacted that give very, very specific guidance about the ways in which advertisers can make environmental marketing claims. Okay, Damaso.
Okay, in Argentina, there is no one specific advertising piece of legislation, but there are various regulations that applies to the matter disseminated in different laws. Historically, we have the fair trading law, which was recently reformed in 2019, which is the most recent legislation. And there you have all the main issues regulating advertising. The regulatory body, the Federal Trade Commission in Argentina, is called the Domestic Trade Secretariat or Bureau. And this law enables the regulator to act ex officio, or at the instance of any party, to start, an administrative procedure and even ask for injunction before a judge. The subject acts are mainly described in Article 11 of this legislation. Apart from that, there has been recently the Civil and Commercial Code in Argentina has been reformed in 2015, and there are now regulation and certain rules on advertising and the prohibition of certain acts. So this is also a brand new law and is applicable to this case. Then we have a certain section in the consumer protection law. We have, of course, the rules of the Paris Convention, which is law in Argentina since many, many years. This from the legislation point of view. But most of the cases in Argentina are decided and regulated and decided by CONAR, the self-regulatory body, which is the most relevant institution. I would say that 80% of all the complaints are resolved there. Most of the companies, multinational and national, are members of CONAR and use and accept the recommendation. So, and CONARB, we will talk about a little bit later, I think, but they issue a paper on environmental claims in communication for commercial purposes.
Thanks, Damaso. So Johan is going to do double duty today and cover both the EU and Denmark.
Yeah, thank you very much. European Union has a sort of two-tier system for many types of legislation. We have the EU system, and they issue directives or regulations, and the normal regulations are directly enforceable in the member states. Directives can be directly enforceable in the member states, and the member states are obliged to implement the directives. We have two different types of directives: minimum directives and full harmonization directives. And in terms of advertising law, we have two very important directives. The UCP directive, the Unfair Commercial Practices Directive, that was passed in 2005, which is a full harmonization directive, which applies to unfair practices B2C. There is some language about environmental claims, but not much. I'll come back later on to what is going on in the EU right now, which is a very important process on in this field. But the UCP directive generally regulates all communication and advertising B2C. We also have the directive from 2006, which is misleading and comparative advertising. It applies to B2C practices, and actually it also applies to B2B practices, and regulates how business entities can market themselves and use the name and logo and other parts of other companies' marketing and comparative advertising. So these two directives that have been put into national law in all the member states regulate the whole area of advertising. And even though there's no environmental mentioning, it will still cover all the advertising issues associated with both environmental claims, sustainability claims, etc. If we come to the Danish Marketing Act, that is an implementation of the EU directives. Denmark has been a little bit slow on implementing laws, even though we are one of the fiercest protectors of the EU as an institution. When it comes to legislation, it tends to be a bit slow. So we've been changing our Marketing Act quite a lot of times because the EU has been dissatisfied with our implementation of the directives. But the Danish Marketing Act applies to all commercial market actors, both private and public, which means to the extent that the state authorities, etc., are actually offering something that could be in competition with private enterprise, they would be covered by the Act as well. All marketing must be done in accordance with best marketing practice and best business practices. That stems out of the directives. Furthermore, all marketing must be clear, unambiguous, and not omit or hide important relevant information. Those rules can be applied directly also to environmental claims, but as I will show later on, a process is going on to actually implement and further define what is this to be and how is this to be understood in terms of environmental claims and sustainability claims. And what is the general purpose and what is actually looked at if we go back once. A commercial practice would be considered as misleading if it may reasonably be thought to significantly alter the economic behavior of the recipients. And all claims must be substantiated. That is going to be further highlighted in the new legislation. So in Denmark we have the Consumer Ombudsman, which I think we were the first or the second country to introduce such a body in our protection of advertising. He acts as a watchdog and issues guidelines for good marketing practice. His biggest problem is that he has limited resources. He will take up cases on his own. You can actually file a claim with the Consumer Ombudsman, but it's not likely that anyone will listen to him, listen to the claims unless he has the resources. Lately, he has been very fierce on ethics and sustainability claims. The Consumer Ombudsman has issued guidelines in 2014 and 2022, and they're under review at the moment. And within the last year and a half, several companies have been targeted in making false or unsubstantiated environmental claims.
Hi there. So, like many other jurisdictions, the regulation in this area can be divided into the kind of the legal regulation on the one hand and the self-regulatory aspects on the other. The legal regulator, the government regulator, is the Competition and Markets Authority, and they enforced the Consumer Protection Regulation in 2008, which was the UK's implementation of the Unfair Commercial Practices Directive from those happy days when we were members of the European Union before we committed our great national act of self-harm. So, and on the other side of the coin, you've got the self-regulatory body, which is the Advertising Standards Authority, which implements two codes called the CAP and the BCAP codes for non-broadcast and broadcast advertising. The main distinction is that the ASA has been looking at many individual advertisements and investigating those, and in the vast majority of cases, upholding the complaints about those ads. And we're going to look at some interesting examples later on. The CMA, on the other hand, tends to look at sectors. So they've launched investigations into various sectors, such as fast fashion and FMCG products. Their investigations move at a glacial pace. The glaciers, in fact, of the North and South Poles are melting more quickly than the CMA is producing its reports. But there is a great deal of consistency between the principles that are applied between these two bodies. So green claims have got to be truthful, accurate, clear, and unambiguous. You mustn't hide or omit important information. And this concept has become increasingly important in what's called green spotlighting. So the ASA in particular are very concerned about, for example, energy companies pointing at their transition towards alternative energy, but not mentioning the fact that they continue to produce a huge amount of carbon dioxide from the traditional things that they do. Comparative claims, touching on Johan's point, comparative claims have got to be fair and meaningful. Substantiation needs to be based on the full life cycle of a product, and that can be a huge problem for sustainability claims, and all claims, not just in this sense, but in across all sectors and all types of claims, must be substantiated by the advertiser before they publish the claims. You can't do it retrospectively.
Hi. So India is currently going through what I call its China phase. That means that there's a lot of development in India, a lot of manufacturers in India coming into India and from India. And for that purpose, similar to UK, we also have a self-regulatory body, the Advertising Standards Council of India, which is recognized by the Supreme Court, which has released its guidelines for advertisements making environmental or green claims. And separately, we have the legal regulations, which is the Central Consumer Protection Authority's guidelines for prevention and regulation of greenwashing. Now, both the guidelines have similar definitions of greenwashing, which refers to unsubstantiated, false, deceptive, misleading environmental claims about products, services, processes, brands, or operations as a whole, or claims that omit or hide information to give the impression that they are less harmful or more beneficial to the environment than they actually are. The CCP definition goes a bit beyond the ASCI definition, in that the CCPA definition of greenwashing does not include use of obvious hyperboles, puffery, or the use of generic color schemes or pictures that don't amount to a deceptive or misleading practice. And it does not apply to advertising that is not specific to any product or service. So similar to the UK, CCPA is also looking at the big picture instead of ASCI, which is looking at the individual advertisers, with CCPA, which is looking at the industry in general. And in addition, the CCPA guidelines mention that the disclosure may be in the ad or by inserting a QR code, URL, or any other form of disclosures. But the ASCI guidelines, in contrast, in fact mention that the disclosure has to be present in the advertisement and not in the form of a QR code. So the consumer should not have to go and check out the disclosure by himself.
Great, thanks, Aakriti. So now what we're going to do is we're going to take a quick tour around the world, give you some highlights, some interesting cases and developments to give you a sense of what's going on. So first we're going to start with the US. I'm really just going to throw up, and I think 4 or 5 interesting developments that I think tell us a little bit about the way the US is thinking about environmental claims right now. The first is a case that this is actually a lawsuit that is pending, brought by the New York Attorney General against JBS USA Food and an affiliate. The company was making a claim in its advertising that it would be net zero by 2040. This kind of should make everyone's stomach hurt a little bit because every single client we're working with right now is making some sort of aspirational claim about when they're going to be carbon neutral. The New York Attorney General decided to go after JBS USA Food for kind of 2 reasons, both of which I think are super interesting. The first is that the Attorney General James did not believe that the way that they were doing their calculation was accurate. And the reason for that was they were not taking into account scope 3 emissions, right? So scope 1 emissions are the emissions that are sort of your direct emissions. Scope 2 is kind of the energy you purchase, and then scope 3 is kind of all your indirect emissions like vendors and suppliers. She was concerned that they were calculating it not excluding scope 3 emissions. So the first issue here is, of course, is that when we're talking about all these new types of environmental claims, you can't assume that we have a common understanding of what they mean. You know, in fact, she's at least saying, well, if you aren't going to define it, you better include scope 3. But it does emphasize, not just here, but really with any kind of environmental claim you're making, particularly ones that are emerging claims, that you really have to explain to consumers exactly what you're talking about. But the second concern that she had, which was, again, one that should make advertisers' stomachs hurt a little bit, is that she just didn't believe that the company had a reasonable plan in place that was going to get them anywhere close to achieving net zero by 2040. Interestingly, though, even though we've gotten very clear guidance from both regulators, from self-regulation, that aspirational claims are claims requiring substantiation. That view is not universally held, however, and there's been at least one court case that kind of scoffed that and said, it's an aspirational claim, consumers don't really believe that you have any proof to back it up. Next case I wanted to talk about was a really interesting case brought against H&M. H&M, the clothing retailer, has a conscious choice collection where they are offering more sustainable shopping. I think a lot of what we're struggling with right now is, advertisers that want to promote their products or their operations as sustainable. I think the thing that makes us nervous about a broad sustainable claim is that it may be understood to be a general environmental benefit claim that communicates a wide range of environmental benefits that may not be able to be substantiated. I think some advertisers want to sort of say, look, we've got some benefit and then therefore we want to promote ourselves as sustainable, or maybe we'll just promote sustainable and sort of take the position that it's puffery. Well, here, H&M was actually not saying that their products were sustainable, they were saying that they were more sustainable. And what the court basically said was, you're not making a sustainability claim, you're making a more sustainable claim, which they felt was substantiated because of the environmental benefits that these products were offering. So the court dismissed the lawsuit. I think it's given us a lot of comfort that if you talk about sustainability in a comparative context as opposed to an absolute context, you're probably going to be in safer territory. But this is another example of a case that really does highlight the increased attention we're seeing on sustainability claims. We've seen many other sustainability claims brought in court where advertisers have tried in one way or another to get the cases dismissed, and courts for the most part have been allowing them to continue, saying that they are potentially misleading. Speaking of using environmental claims that people may not understand, this is a very interesting case involving Avion. Avion was promoting itself as being carbon neutral. It had a carbon neutral certification, and the issue in this case really was, what does carbon neutral mean, and do consumers understand what carbon neutral means? This is not something unique to the US. We've seen this issue come up around the world as well, which is that, ultimately what the question here is, if you've bought carbon offsets to offset your emissions, is that enough to make a carbon neutral claim? Or are consumers actually going to understand a carbon neutral claim to communicate that you're not actually emitting any carbon whatsoever in connection with the production process? The court here thought that that was potentially misleading. They allowed the case to continue, and the court did not have any interest at all in saying, yes, it's okay that there's a disclaimer, that consumers can learn more. I think that this is going to be one of the interesting evolving issues both in the US and around the world, which is, are disclaimers going to be effective here? What research can we allow or can we require consumers to do? And in fact, what kinds of information are we going to be required to tell consumers, either on their packaging or somewhere else? Another really interesting issue that we're seeing pop up in a lot of different ways is this sort of the difference between what is theoretically possible and what is actually possible. We have seen over the last several years a number of cases involving advertisers making recyclability claims where the products themselves are recyclable in the sense that they are made of a plastic or a material that is capable of being recycled, but there have been challenges to whether in practice those products can in fact be recycled. So here the concern was that although the packaging was in fact recyclable, the municipal recycling systems weren't in fact accepting them or recycling them because they weren't sure whether in fact they could distinguish between recyclable and non-recycling packaging, or whether the remaining toothpaste in the tubes somehow impacted the recyclability of the products. And we're seeing this come up a lot because as advertisers work hard to create products that are environmentally preferable, that can be recyclable, we still have this challenge that we don't have a recycling system that can necessarily support all of the recyclability that's out there. There was also an interesting lawsuit as well as a workshop at the FTC on, are you responsible for more than just ensuring that a product will be accepted by recycling systems, but in fact that the product actually will be not only accepted, but in fact turned into recyclable material and recycled. FTC held a whole workshop on that. We're all waiting to see whether the FTC's guides are going to come out with new guidance on that front, but at least one court decision said that they didn't believe that a recyclable claim was any kind of promise by an advertiser that the product was in fact going to ultimately be turned into something else. Earth-friendly, we've started to see some cases about general environmental benefit claims. The court here held that that earth-friendly is not puffery. It really is an general environmental benefit claim that requires that is going to communicate various claims that are going to require substantiation. What I thought was interesting about this case is that the advertiser is making several claims here, both about earth-friendly and about that the product was non-toxic. And there were disclosures as well. On the front of the packaging, there was a disclosure that it was an eye and skin irritant. And on the back of the packaging explained what the benefits were to support the earth-friendly claim. Court didn't dismiss the case, allowed it to proceed, basically raising the question, just not sure that those kinds of disclaimers are either sufficient or ones that are going to be taken in by consumers. And finally, just in terms of emerging state laws, California has been one of these places that has been on the forefront of enacting new environmental standards. Kind of the two statutes that's got everyone worried right now are number one, AB 1305, which is a statute that says if you're making any kind of essentially carbon neutral or net zero claim, you're going to be required to include, by the end of the year, disclosures on your website explaining in detail what the basis for those claims are. And then the FTC also, California also issued also passed a new law about recyclability claims and the use of the chasing arrow symbol. basically what California is in the process of doing is doing a very broad study to look at what in fact is recyclable in the state of California. And in order to make any kind of recyclability claim in the state of California, you will need to ensure that the product is recyclable in accordance with California standards based on the data collected by the state of California. Now we're going to go to Damaso.
Okay, sorry. Again, all of this concept about zero emission, carbon neutral, and all these new matters on environmental laws are found in different laws, but none related or addressing greenwashing or environmental claims within the advertising industry. So no single rule about that. The only thing we have is the CONAR, which is the self-regulation body in Argentina, and they set up a kind of paper with guidelines. Most of the content was taken from the International Chamber of Commerce, the World Federation of Advertisers, and the International Council for Advertising Self-Regulation. So basically, there you can find the guidelines and the rules that would apply if a case is decided by CONAR. And basically, all the environmental claims must be truthful and not misleading the consumer, be able to provide evidence, so it has to be substantiated, and the substantiation must be robust, objective, ascertainable, and made by an independent scientific entity, knowing exactly the business or the industry to the product is related. They will also clearly specify which product life cycle is being discussed and justifies its relevance. It must include a final impact that is both significant and meaningful, and it must mention sources, legal requirements, and certification. Basically, there are two paragraphs which I highlighted for this presentation, and well, greenwashing refer to the deceptive use of environmental terms and visuals without proper evidence, or when the presentation of a message is likely to cause confusion and misinformation among the public. And the advertiser brand and the industry as a whole are both negatively impacted when relevant data is omitted, the content or scope are presented ambiguously, or benefits are exaggerated without justification, potentially harming consumer confidence and questioning industry credibility. Well, then I unfortunately we do not have any case reported by CONAR in the last year, 2023, on greenwashing. So I asked some of my colleagues from Brazil, and Vadehra brought us this case. This is a company called Native, and they sell most of the products under the trademark Native. This is a kind of chocolate coffee, milk product, and a group of consumers questioned the use of the word ecological in the packaging of this product. And the company said that they comply with relevant laws, but CONAR considered that the can, in spite of the can is recyclable, the steel used in the package is not ecological. So they considered that it was greenwashing and recommended to be stopped. Then we have some cases from Colombia. Here the issue is the use of certifications by companies that certify whether the product comply with any of the claims mentioned. And there are two companies who are being investigated. One is Unisocial, and the other one is MAG, the product MAG. The thing here is that one of the companies was requested to substantiate claims which would not be able to do, and it was in violation of the rules. And the other case, the Superintendence of Industry and Commerce, which is the regulatory body in Colombia, requested MAG to sustain the organic claim of the packages. And they did that, but unfortunately they don't have the proper authorization. The company certification did not have the proper authorization of the ministry. This last case relates to a company, Detergentes Limitada, who was selling a product, Top Terra, apparently being the first ecological detergent in the market. And again, the superintendents required the company to prove each of the claims made with the advertisement. The company answer and provide information about the claims mentioned, but it was not done by independent source and a technical entity with enough authority to provide these conclusions. So it was not considered allowed. And finally, it's interesting mentioning in Peru, there are many issues and cases on greenwashing addressed by Indecopi. Indecopi is the regulatory body. It has a huge jurisdiction because not only here cases on patent, trademarks, and copyright, but also antitrust, and also things about advertising. And they just released also, like Argentina, guidelines on how to use environmental claims.
Okay, great. All right, Johan, you got 2 jurisdictions here, of course.
Yes, thank you. In terms of the EU, we have a very nature-positive European Parliament at the moment. The Parliament is up for election in June of this year, and it's expected that the new Parliament after June will be less nature enthusiastic due to a number of issues arising around the world. So for that reason, it is a kind of a bumpy road, I guess. We have a proposed Green Directive as part of the European Green Deal, and the European Green Deal is a big framework requiring Europe to become the first climate neutral continent, and it's a very ambitious plan. And as part of that, the EU has proposed a change to the current directive, the UCP directive, to include a section about green claims. So it stems out of studies made by the Commission in 2020 that about more than 50% of examined environmental claims were found to be vague, misleading, or unfounded, and 40% were unsubstantiated. The directive is on a path where it has just been through Parliament. It was expected to be issued in mid-February of this year, and that's already passed. So the European Parliament just issued their comments that were a bit stricter than what the Commission came up with, and now it's up to the member states' governments and the Council to adopt the final version of the directive. So we'll have to see. It's expected that the council may slow down a little bit on the current version, but we'll have to see what happens. In terms of the proposal, it will include a new definition of environmental claims. There's nothing really extremely interesting, except it's any message or representation which is not mandatory under union law, which means it's very broadly applicable, so that if you make advertisement that looks unnecessarily good, it may not be the direct claims that are targeted, but also the whole perception of the advertisement may be targeted in relation to environmental claims. And what is specifically targeted is elements of advertising which states or implies that a product or trader has a positive or no impact on the environment, or is less damaging, or that the advertiser has improved their impact over time. It will also add definition of terms such as explicit environmental claim and generic environmental claims. So the Article 6 of the current directive will be expanded to explicitly comprise environmental and social impact, accessories, durability and repairability. So this is part of a bigger a bigger load of legislation which will also talk about durability and repairability. There is a blacklist associated with the directive about do's and don'ts, and that will be amended to include certain environmental claims. Also, substantiation will be more prominent. For the time being, the law is that substantiation can be shown after the advertisement has actually been aired, but now the Commission is strengthening that requirement, so every time an advertiser wants to make a claim for environmental claim, they must have conducted a thorough research in advance whether they actually can substantiate the claim. And the substantiation must be done through a third-party independent authorization, not something that you create yourselves. So that's going to be quite an important different from the current legislation. And then also, what do you have to show? You have to be able to show that information is actually affixed to the product, or that the trader has you can get a direct access through a QR code or something equivalent. If you use QR codes, it must be easily understandable, easy to get. It's not just that you're linked to the main page of the company, but the information must be very easily accessible. And then it will also include a list of information that's necessary. It's about aspects and standards used. It's about underlying studies having been conducted or referred to. And finally, what is expected is that the penalties for breaking these rules will be quite excessive and asserted according to the turnover of the company. It's not specifically mentioned in this law, but it has been applied to the GDPR law framework and also to the anti-competition framework. In relation to Denmark, there's not much to say of new things in terms of legislation, but it is so that if you make a claim for sustainability, you must take into consideration not only sustainability in relation to the environment, but also in relation to ethical, social and health issues. And then the Consumer Ombudsman generally recommends against making claims for sustainability, because basically speaking, it's almost impossible to actually prove sustainability of a product. We just had a case fresh off the press in Denmark. A climate organization, NGO, sued the major manufacturer of meat in Denmark, Danish Crown, for making false claims in relation to the climate. They put a sticker on their minced meat talking about climate-controlled pork and talking about Danish pork is more climate-friendly than you think. And it was a major case. They actually removed it very quickly because they claimed that they understood that the market didn't really understand their claims, so they didn't want to disturb the market. But they still got sued, and the case was decided just last week. So we are still debating what it's all about. The first part of the claim was that they referred to the consumers to not understand that pork was actually more climate friendly than they thought. The court analyzed the claim, saying you're not really making a green claim, but you are sort of referring to the perception of the public. So in that relation, it's not a factual claim, but it's a relative claim. And then they went on to examine whether it was actually substantiated, and the butcheries were referring to several researches done that people, the ordinary consumer, did not really understand that pork was less climate hostile than meat and than beef and lamb chops, which is actually true. And then the court finally decided that the claim was found not to be misleading. We're still debating this part because you could argue that just the fact that you raise the issue of climate friendliness would be considered by the consumer to be a positive element as a factual claim. So the case that Jeff just referred to sort of falls within the same decision, the same outcome as this one, but I would expect that this case is going to be heard by the Supreme Court, where the climate NGO will claim that just the fact that you raise the issue of climate friendliness is indicating that it is really good for the climate. But we'll have to see where that ends. The other one is the claim that it was under climate control. The butcheries had set up their own mechanism for checking this, which is very, assuring and definitely very valid. But there was no official way to actually control whether it was climate control. And what does climate control means? The court stated that this is actually a factual claim, and since they did not have a third-party neutral way to do the control, this claim was found to be misleading. So it's a very important case. Furthermore, the Consumer Ombudsman has targeted several types of advertising, and the Danish Consumer Ombudsman is not scared off that he's targeting very big international companies. He was once on the front page of the New York Times for targeting a US company in Denmark. But now he's targeted Mercedes-Benz because Mercedes-Benz was talking about the green revolution and certified climate-friendly Mercedes-Benzes. I've taken in the ad itself because I think it's very reassuring in the fact that, making a 2-ton vehicle for a lot of people, selling it at a low price is definitely beneficial to the environment. You definitely get that feeling when you see the video. Stacy? There's no sound. Okay, it's without sound. Okay. You have to take in the beautiful pictures. Ah. It's soothing music, and people, children playing, and nature at its best. And it actually ends with the Mercedes propeller turning into a windmill, as you can see at the top. So, and it talks about the production in 2022 will obtain electricity only through renewable sources. That's one of the claims made, and the other claim was, they talked about the Green Revolution. What the Consumer Ombudsman has done is he can issue fines if he consider a claim to be very obviously misleading and a case very easy. But in this case, the investigation would include investigations into Mercedes-Benz actual doing in Germany when they produce the car. So the Consumer Ombudsman has asked the police to investigate and maybe raise claims against Mercedes-Benz. We don't know where that is ending. Another case we had was that a number of manufacturers of electric cars were pooling together and claiming that 0 grams CO2 emission while driving. And although the Consumer Ombudsman found that to be a correct claim, he didn't consider the claim to be fully substantiable in relation to the full impact of producing, buying, and driving an electric car. So the advertisers were only focusing on one aspect of that, of having and using an electric car, and for that reason the Consumer Ombudsman found it to be misleading green claim.
Because that's really interesting. Because in the UK, our regulators have basically taken the opposite view, which is that provided you caveat those claims with words like while driving, then it's okay to say 0 emissions. So we're such close neighbours, and yet our regulators have taken diametrically opposed views on the same point.
Yeah, and unfortunately we haven't, what happens often is that advertisers are not very happy about being the target of the Consumer Ombudsman. So normally the cases will end with negotiations, and then the advertisers will withdraw the advertisement, and then the case is done. And in this case, that was the end of it. So we haven't had a court to actually review whether this would be proper. If we look at the case with the pork, if you state while driving, the court may very well come to the opposite decision. I agree. This was about burning candles. A company was claiming cleaner burning, less sod, better for you and the indoor environment, and that was considered an environmental claim. Substantiation was missing, and thus it was an illegal claim. The next one is, I know I have New York taxis here. They're not driving around Copenhagen, thanks God. Then everyone would be jumping for their life. But we have electric cars for taxis, and we have a requirement that taxi companies, when they buy new taxis, they must buy taxis with energy class C or better. And this company was just putting a big sticker on their cars claiming climate-friendly drive, this taxi is energy class C or better. And since that was a general requirement, they were no better than the rest of the taxi companies, and for that reason it was a claim unfounded.
Hi. Right, yes, so this one is very interesting. This started, I mentioned about green spotlighting. So the claim on this ad, it's a view of a beach by HSBC, the global bank. HSBC is aiming to provide up to $1 trillion in financing and investment globally to help our clients to net zero. So not actually claiming that they're getting net zero, but claiming the 1 trillion. Now, in fact, that claim is factually true, but what they failed to mention in the ad is that they're also financing 65.3 million tons of carbon dioxide from oil and gas, and that they're going to continue with similarly kind of non-green activities being financed. Information which came from their own annual report. So an outfit called Ad Free Cities lodged a complaint about this ad and basically turned HSBC's own published information against them. And so this was resulting in a ban by the Advertising Standards Authority. HSBC were very upset. They thought it was all terribly unfair. But I think it's probably the correct decision. And this was important because it was the first case really about green spotlighting. Now, on the next page, we see at the same time as they lodged their complaint about HSBC, Ad Free Cities also lodged a complaint about a campaign by BP, British Petroleum. And as you can see in that, you've got a picture of a carbon capture kind of blueprint of the plans for a carbon capture plant. And then down the left-hand side, you've got a number of icons which say oil and gas, hydrogen, wind, carbon capture, EVs, sustainable fuel and solar. And crucially, oil and gas is at the top, which helped, but then they also have their disclaimer or mea culpa. Today, most of our production is oil and gas, but as we transition towards net zero, that will change. This decade, we plan to increase to 50% our capital expenditure on our transition business globally and reduce oil and gas production by around 40%. Now, in this case, the Advertising Standards Authority simply decided that they were not going to launch an investigation because they felt that BP had done a good enough job of disclosing the fact that they are still primarily an oil and gas company. Unfortunately, they didn't make a public decision, so this decision is not as well known as it might be, but it is very significant. And so far, BP, with the help of some external legal advisors, have managed to avoid any investigations by the ASA. This one is much more recent, and this one also interesting. So you've got a picture there of an engineer pointing in the North Sea beyond an oil platform, with the headline, "It's all part of the broader picture, or the broader energy picture: wind, oil, gas, carbon capture, and new jobs." And then they say, Equinor has been delivering energy solutions to the UK for 40 years, and we are now working to help the UK achieve a smooth energy transition. We're producing the oil and gas the UK needs now, and we'll be powering millions more homes with wind, capturing and storing carbon safely. It's broad energy for a brighter future. Well, you might think, having seen the BP ad, you might think, well, okay, so what's the problem? Because they're also delivering their mea culpa of we are in oil and gas. The problem is there's no sense of proportion here. They are delivering wind energy and carbon capture, but it's a very small proportion of their overall activity, which is still overwhelmingly oil and gas. And so the ASA said, no, this is also misleading, and we're going to uphold the complaints about it. This is a TV ad. This is great.
One of nature's true spectacles. New Toyota Hilux. Born to roam.
I'm not sure. Okay, so this is really significant because last summer the ASA produced new guidance about social responsibility in environmental advertising, and they've had a long-standing rule that says advertisements of any kind must be prepared with a sense of social responsibility. But they said we're specifically going to be looking at this in relation to green claims. And then in November they published their 5-year plan, and they said, one of our top 5 priorities for the next 5 years is going to be green claims. And the other thing they did, which I think is very relevant to advertisers in the US, they have now also changed their working practices, which mean that if, for example, you had a Facebook ad and you paid for it to be promoted towards UK consumers, the ASA will investigate it and uphold complaints about it, and then they'll work with, for example, Facebook to get it removed from the UK. So there's much greater jeopardy now, I think, for US advertisers than there used to be. And in this one, the ASA said, well, having all those Toyotas driving off-road, even though the environment was not a particularly sensitive one, that would be damaging to the environment, and therefore it broke the rule on social responsibility. Toyota said, well, hang on a minute, this is clearly a fantasy where you're never going to be able to get together that many cars in one go and drive them all off-road in that way. But some of the depictions were more realistic, and so the ASA didn't allow them to kind of salami sliced in that way. Quite a harsh decision, I think. But that's definitely the direction of travel, and that was specifically on this point of social responsibility. Sustainable aircraft fuel. I don't think my client is here from a New York ad agency that is representing a US agency, a US airline, who like to make great play of their sustainable aircraft fuel. The Advertising Standards Authority is having none of it. As far as they're concerned, the whole claim that you can make sustainable aircraft fuel is nonsense. It's such a tiny percentage of the fuel used by any airline that so far all of these claims, this was one for Lufthansa, connecting the world, protecting its future with sustainable aircraft fuel. I mean, the stuff works, and there was recently a Virgin airline flight that flew from London to JFK using sustainable aircraft fuel. Great, but technically, yes, it can be done. Is it being done in practice? No, it is not. So for the time being, all these complaints have been upheld, and I think are likely to be until there's a massive upscaling in the production of the stuff. And then I think this is my final example. So EV charging, just to say, there's two issues really around that everybody is being caught out with a lot on this. One is about the rate of charge. So these claims that you can charge a battery to 80% in 30 minutes. And another is about the range claims. There's a real challenge here for advertisers because there is an accepted, I think it's called the WTLP. That might be I might be giving those initials in the wrong order because I'm dyslexic, so I never say them in the same order twice. But it's something like that. And it's a recognized test, and it's a very useful test for allowing you to compare the performance of different EV vehicles one with another. What it is not very useful for is getting a sense of how your car will perform in the real world, when the battery might be hot, or the battery might be cold, or it might be new, or it might be old, and so on and so forth. And there are lots of different factors that can affect it. So unfortunately now, increasingly, we're having to come up with really quite long explanations of, this is a kind of, in test conditions, in reality, all these different things are going to affect what you can achieve. So these are just fairly recent examples that affected Hyundai and Toyota, but I've been working with other car manufacturers and also with a certain energy company, and it's very, very challenging to make these claims, so you have to be super careful.
Aakriti.
So moving back to India, I wish I had more cases similar to my companions, but unfortunately we do not, as yet at least. So I'll just be going through good practices and once again the guidelines. So both the ASCI guidelines and the CCPA guidelines say that environmental claims are claims that suggest or create an impression that a product or service has a neutral or positive impact on the environment, is less damaging to the environment than a previous version or a competing product, and has specific environmental benefits. So the picture that you see on your right is a typical example of a green claim in India. It is the ITC's ad for Nimili, for a floor cleaner, which has no chemical residues, is herbal, has 100% natural action, no chlorine, no bleach, etc., etc. So the good thing, rather good thing for me, is that I just happened to Google this particular brand in the morning, in fact, just before coming here, and there has in fact been a complaint raised against ITC for this particular product with the ASCI, the Advertising Standards Council of India, because even though they say that there is 100% natural action, the ingredients that is mentioned in the back of the product says that there is a fragrance, an artificial fragrance present in the product. So is it misleading? Is it false? Or is it do they omit information? That remains to be seen, because this complaint was raised just in fact back in India that the morning of yesterday. So it remains to be seen how the ASCA is going to handle this complaint. Now, back again with the Nimili product, absolute claims must be capable of being substantiated rather than just, giving a natural, 100% natural action. And then the absolute claims cannot be diluted by means of a disclosure or any other clarifying mechanism. And of course, general environmental claims must be based on the full life cycle or must disclose any limitations. They can be more limited claims about specific aspects they are okay. And the general environmental claims should not mislead consumers about the total environmental impact. Next, coming to comparative claims. Comparative claims require evidence. First of all, comparative claims in general are allowed in India. They're not a problem. But of course, no matter whether they are comparative claims or environmental comparative claims, they need evidence. And the basis of comparison should be made clear. As far as compostable, biodegradable, and recyclable claims are concerned, they are also required to be substantiated by competent and reliable scientific evidence. Now, the image that we have here is a good practice image. So, Hindustan Unilever, they have on their website that they are completely they recycle, or they are free of food loss and waste. And this claim of theirs is substantiated by an Excel sheet that is again available on their website that actually gives full disclosure, full data for financial years 2022-23, and going back a number of years with each category of waste that they have disposed of or that they have reused in their practice. So this is something that advertisers or that brands can actually practice while giving advertisement claims. They can also give a disclosure or some sort of Excel sheet on their website that is capable of substantiation. Then for carbon offset claims and aspirational claims, I have a video here. So.
Operations by the year 2046. On the 99th year of our independence, Indian Oil will be independent of operational emissions. A bold initiative backed by bigger steps.
Okay, so this is not the complete video, I clipped it out. Complete video is available on YouTube that actually defines how Indian Oil is going to achieve net zero operations by 2046. In addition, on their website, they have an ongoing emission mitigation efforts, which is again backed by an Excel sheet that clearly defines what kind of efforts they are doing to achieve net zero by 2046. And this is exactly what is expected out of brands. In terms of carbon offset claims, it is required to clearly and prominently disclose if the offset will not occur in the next 2 years. So once again, they mention it clearly that we do not expect to achieve carbon offset in the next 2 years. We in fact expect to achieve it in 2046, which just happens to be our 99th year of independence. And then for aspirational claims, even the guidelines suggest you to refrain unless you have clear and actionable plans on how these objectives will be achieved. Indian Oil does a very good work of defining their clear and objectionable plans. Next, coming on to visual elements, don't include an environmental color scheme or image unless connected directly to an environmental claim which is made. Do not mislead consumers by highlighting the absence of an ingredient that is usually included. For example, the fragrance ingredient that I mentioned with the Nimili product, and environmental benefit that is legally required. For example, it is legally required in India to not mislead consumers, and this is another thing. So be specific about what claim the claim applies to. Don't claim a product is free of a substance that it has other similar harmful ingredients, which I have an example in the next slide. And if it is certified, clarify what attributes have been evaluated. So this is a complaint, another complaint that was raised to ASCI about Devgya Organics. This is a made in India product, made in India brand, that skincare brand that uses visual elements and terms like cruelty-free and sustainable products to endorse their products. Now, a concerned, probably disgruntled citizen raised a complaint to ASCI about their claim for substantial products and their tag that none of our products comes at the cost of environment. ASCI's Consumer Complaint Council investigated and they instructed Devgya to further submit evidence in favor of these claims. However, they could not substantiate them. Therefore, CCC upheld the claim and decided that claims are in fact misleading. So circling back to the free of claims, ASCI and CCPA guidelines both prescribe not to say a product that is free of one thing but has other similar harmful products. And last but not the least, companies are free to certify their products from national or international certifying organizations. But in your marketing campaign, when you say that your product is certified, you are required to substantiate on what attributes are certified.
Awesome, thanks all. Okay, we're gonna take a quick 10-minute break so people can stretch their legs, get some coffee, and then we're gonna come back here for our last panel, which is a tour of some other hot topics around the world. We'll see you in 10 minutes.